Question 1. In an environment where different components must interact to ensure equal voting access, a state implements a voter ID law requiring specific government-issued identification to cast a ballot. A civil rights group challenges this law, arguing that it disproportionately affects racial minorities and low-income voters. Which of the following legal standards would a court likely apply when evaluating this law under the Equal Protection Clause of the 14th Amendment? A. Rational basis review. B. Intermediate scrutiny. C. Strict scrutiny. D. Preponderance of the evidence. Answer: C. Strict scrutiny. Explanation: under the Equal Protection Clause of the 14th Amendment, courts apply different levels of scrutiny depending on the classification involved. Voting is considered a fundamental right, and when a law disproportionately impacts a protected class, such as racial minorities, courts generally apply strict scrutiny. Strict scrutiny requires the government to prove that the law is narrowly tailored to serve a government interest and is the least restrictive means of achieving that interest. In cases like Shelby County v. Holder 2013 and Crawford v. Marion County Election Board 2008, the Supreme Court has evaluated voter ID laws under various standards, with opponents arguing that they disenfranchise minority voters. Rational basis review A applies to most general laws that don't involve fundamental rights or classifications. Intermediate scrutiny B is used in cases involving gender discrimination, not voting rights. Preponderance of the evidence D is standard of proof used in civil lawsuits, not constitutional test. Question 2. During a comprehensive review of a process that needs improvement, a public school district revises its disciplinary policies. The new policy results in higher suspension rates for Black and Hispanic students than their white counterparts for similar infractions. Civil rights advocates file a lawsuit under Till Romans, the Civil Rights Act of 1964. Which of the following must the plaintiff prove to successfully challenge? Policy A. That the policy has a discriminatory intent against minority students. B. That the policy has a disparate impact on minority students regardless of intent. C. That the policy violates the Fourth Amendment's protections against unreasonable searches. D. That the policy is contrary to state-level anti-discrimination laws. Answer: B. That the policy has a disparate impact on minority students regardless of intent. Explanation: Till Romans, the Civil Rights Act of 1964 prohibits discrimination based on race, color, or national origin in federally funded programs, including public schools. Courts have recognized disparate impact claims in civil rights cases, meaning that plaintiffs do not necessarily need to prove intentional discrimination, only that the policy has disproportionately harmful effect on protected group. In Alexander v. Sandoval, 2001, the Supreme Court limited private lawsuits under Till Romans, but federal agencies like the Department of Education can still enforce disparate impact regulations. Intentional discrimination is not required for successful disparate impact claim, while proof of intent strengthens case disparate impact and allows challenges based on statistical evidence alone. Fourth Amendment concerns C typically apply to search and seizure issues, not school discipline policies. State-level laws D may provide additional protections, but they are not the basis for claim under federal Till Roman 11. Question 3. While examining inconsistencies across various units in a housing authority, a civil rights investigator finds that landlords in a particular district refuse to rent to tenants using federal housing vouchers. A complaint is filed under the Fair Housing Act (FHA). Which of the following best describes how the FHA protects against this form of discrimination? A. The FHA only prohibits intentional discrimination, so the landlords must have stated an explicit intent to exclude voucher holders. B. The FHA covers only race, color, religion, sex, and national origin, but does not apply to discrimination based on source of income. C. The FHA prohibits both intentional discrimination, disparate treatment, and policies with discriminatory effects, disparate impact. D. The FHA applies only to public housing authorities and does not regulate private landlords. Answer: C. The FHA prohibits both intentional discrimination, disparate treatment, and policies with discriminatory effects, disparate impact. Explanation: the Fair Housing Act (FHA) of 1968 prohibits discrimination in housing based on race, color, religion, sex, national origin, disability, and familial status. Courts have interpreted the FHA to cover both disparate treatment, intentional discrimination, and impact neutral policies that disproportionately harm protected groups. In Texas, Department of Housing and Community Affairs v. Inclusive Communities Project Inc. 2015, the Supreme Court affirmed that disparate impact claims are valid under the FHA, meaning plaintiffs do not need to show direct intent to discriminate, while source of income e.g. federal housing vouchers is not explicitly protected under the FHA at the level. Some state and local laws extend protections to voucher holders. Option is incorrect because the FHA does not require proof of explicit intent to exclude protected classes. Option B is incorrect because courts have recognized FHA claims based on the disparate impact of housing policies, even if the law does not explicitly cover source of income. Option D is incorrect because the FHA applies to both public housing authorities and private landlords, including those renting to voucher holders. Question 4. During a critical transition period where existing processes for voting rights enforcement are being reevaluated, a newly enacted state law imposes strict voter ID requirements leading to a lawsuit under the Voting Rights Act of 1965. Plaintiffs argue that the law disproportionately disenfranchises minority voters. The state government defends the law as necessary for election integrity. Which of the following principles will be most relevant in determining whether the law is unconstitutional? A. The doctrine of strict scrutiny under the Equal Protection Clause. B. The state's power under the Elections Clause to regulate voter qualifications. C. The rational basis test applied to voting regulations. D. The privileges and immunities clause of the 14th Amendment. Answer. A. The doctrine of strict scrutiny under the Equal Protection Clause. Explanation. Under the Equal Protection Clause of the 14th Amendment, voting laws that impose burdens based on race or disproportionately affect racial minorities must pass strict scrutiny. Strict scrutiny requires the government to prove that the law serves a compelling interest and is narrowly tailored to achieve that interest. Courts have repeatedly held that laws affecting rights in a racially discriminatory manner are subject to strict scrutiny. G. Shelby County v. Holder 2013. B. Incorrect. While the Elections Clause, Article I, Section 4, allows states to regulate the times, places, and manner of elections, those regulations cannot violate other constitutional protections such as the Equal Protection Clause or the Voting Rights Act. C. Incorrect. The rational basis test apply to most general regulations, but not when fundamental rights like voting are at stake. Instead, courts apply a higher standard of scrutiny to voting rights cases. D. Incorrect. The Privileges and Immunities Clause protects against discrimination between citizens of different states, but is not typically used to analyze state voting laws. Question 5. In a high-stakes environment where multiple challenges arise in criminal justice reform, a state enacts a law allowing police to conduct stop-and-frisk searches in high-crime areas without any specific suspicion. A civil rights group challenges the law, arguing that it disproportionately targets racial minorities. Which constitutional principle is most relevant in evaluating the law's validity? A. The Due Process Clause of the Fifth Amendment. B. The Fourth Amendment's protection against unreasonable searches and seizures. C. The Takings Clause of the Fifth Amendment. D. The Supremacy Clause of the U.S. Constitution. Answer. B. The Fourth Amendment's protection against unreasonable searches and seizures. Explanation. The Fourth Amendment prohibits unreasonable searches and seizures. In Terry v. Ohio, 1968, the Supreme Court ruled that stop-and-frisk searches are constitutional only if officers have reasonable suspicion of criminal activity. Law allowing random, suspicionless stop-and-frisks would likely be struck down as unconstitutional under Terry and sub-rulings. A. Incorrect. The Due Process Clause protects individuals from arbitrary government action but is not the primary basis for evaluating stop-and-frisk policies. C. Incorrect. The Takings Clause relates to government seizure of property, which is not relevant in stop-and-frisk case. D. Incorrect. The Supremacy Clause ensures federal law overrides state law, but this is not the core legal issue in Fourth Amendment challenge. Question 6. While investigating a complicated issue between different government agencies regarding the rights of non-citizens, an immigration detainee challenges prolonged detention without a bond hearing under federal law. The government argues that non-citizens can be detained indefinitely under immigration authority. What is the most relevant constitutional protection at issue? A. The First Amendment's right to petition the government. B. The Equal Protection Clause of the 14th Amendment. C. The Due Process Clause of the Fifth Amendment. D. The Commerce Clause's regulation of interstate migration. Answer. C. The Due Process Clause of the Fifth Amendment. Explanation. The Due Process Clause of the Fifth Amendment applies to all persons, including non-citizens, The Supreme Court in Zavidas v. Davis 2001 held that indefinite detention without judicial review violates due process unless the government shows a valid justification for continued detention. A. Incorrect. The First Amendment protects speech and the right to petition, but it does not directly apply to detention challenges. B. Incorrect. The Equal Protection Clause applies to state actions, while this case deals with federal immigration law. D. Incorrect. The Commerce Clause regulates interstate trade, which is unrelated to immigration detention. Question 7. During a major transformation where existing methods of ensuring fair housing are being reevaluated, a city implements zoning laws that result in disproportionately high housing costs in minority neighborhoods. A civil rights lawsuit is filed under the Fair Housing Act. What must the plaintiffs prove to succeed under a disparate impact theory? A. That the government had an explicit intent to discriminate. B. That the zoning laws had discriminatory effect regardless of intent. C. That reasonable person would perceive the law as unfair. D. That the zoning laws violated state constitutions. Answer. B. That the zoning laws had a discriminatory effect regardless of intent. Explanation. Under Texas Department of Housing and Community Affairs v. Inclusive Communities Project 2015, a plaintiff in a disparate impact case does not need to prove intentional discrimination. They must show that the law disproportionately harms a protected group and that the government cannot justify the practice as necessary. A. Incorrect. Intentional discrimination is not required under disparate impact claim. C. Incorrect. Disparate impact is determined by statistical analysis, not subjective perception. D. Incorrect. The Fair Housing Act is federal law and violations are based on its provisions, not state constitutions. Question 8. In a high-stakes environment where multiple challenges arise in law enforcement policies, a city passes an ordinance allowing the use of facial recognition technology in all public spaces. A civil rights group challenges the ordinance, arguing it violates constitutional rights. Which legal principle is most relevant in evaluating the challenge? A. The First Amendment right to free speech. B. The Fourth Amendment's protection against unreasonable searches. C. The 10th Amendment's state sovereignty provisions. D. The Due Process Clause of the Fifth Amendment. Answer. B. The Fourth Amendment's protection against unreasonable searches. Explanation. Facial recognition technology raises Fourth Amendment concerns because it can lead to warrantless mass surveillance, potentially violating the reasonable expectation of privacy principle from Katz v. United States, 1967. Courts assess whether such technology constitutes an unreasonable search, as seen in Carpenter v. United States, 28. Regarding cell site location data, A. Incorrect. The First Amendment protects speech, but facial recognition primarily implicates privacy, not speech rights. C. Incorrect. The 10th Amendment concerns state power, but this case involves constitutional limits on government surveillance. D. Incorrect. Due process is crucial in privacy cases, but facial recognition is more directly Fourth Amendment issue. Question 9. While investigating a complicated issue between different jurisdictions regarding the rights of transgender individuals, a state law bans transgender students from using restrooms that match their gender identity. A lawsuit is filed arguing the law violates federal protections. Which legal doctrine is most relevant? A. Title IMC's prohibition of sex discrimination in education. B. The Commerce Clause regulating interstate issues. C. The Takings Clause of the Fifth Amendment. D. The Full Faith and Credit Clause. Answer. A. Title IX's prohibition of sex discrimination in education. Explanation. Till Roman prohibits sex discrimination in federally funded schools. The Supreme Court has recognized in Bostock v. Clayton County 2020 that discrimination based on gender identity is a form of sex discrimination. Lower courts have extended this logic to school bathroom policies. B. Incorrect. The Commerce Clause governs economic regulation, not civil rights in education. C. Incorrect. The Takings Clause applies to property seizure, not civil rights violations. D. Incorrect. The Full Faith and Credit Clause concerns state recognition of laws and court judgments, not federal education protections. Question 10. During an emergency response where multiple areas are impacted, a governor issues an executive order suspending public protests due to a state of emergency. Civil rights advocates challenge this action. What is the strongest legal basis for their challenge? A. The First Amendment right to free assembly. B. The Equal Protection Clause of the 14th Amendment. C. The Necessary and Proper Clause. D. The Third Amendment's prohibition on quartering soldiers. Answer A. The First Amendment right to free assembly. Explanation. The First Amendment explicitly protects the right to peaceably assemble, while governments can impose reasonable time, place, and manner restrictions. A total ban on protests is likely unconstitutional under McCullen v. Coakley 2014. B. Incorrect. Equal protection applies when laws discriminate against specific groups, but the core issue here is assembly rights. C. Incorrect. The necessary and proper clause applies to federal actions, not state emergency powers. D. Incorrect. The Third Amendment is unrelated to civil rights or protest bans. Question 11. When implementing new protocols in a shared environment, a private employer enacts a policy restricting employees from wearing religious attire at work. An employee sues, claiming religious discrimination. Under which law is this lawsuit most likely filed? A. The Civil Rights Act of 1964, Title E, the First Amendment's Free Exercise Clause. C. The Equal Pay Act. D. The Takings Clause. Answer A. The Civil Rights Act of 1964, Title Roman Explanation. Title Roman prohibits employers from discriminating based on religion and requires them to provide reasonable accommodations unless it creates an undue hardship. Eoc v. Abercrombie and Fitch 2015. B. Incorrect. The First Amendment applies to government restrictions, not private employers. C. Incorrect. The Equal Pay Act concerns wage disparities, not religious discrimination. D. Incorrect. The Takings Clause applies to property, not employment policies. Continuing with similar detail for questions 1 to 17. Question 12. While analyzing the root causes of sequential problems in voting access, a state passes a law requiring strict voter ID at polling places disproportionately affecting minority communities. A lawsuit is filed challenging the law. Which constitutional provision is most relevant? A. The 15th Amendment's protection against racial discrimination in voting. B. The Fourth Amendment's prohibition on unreasonable searches. C. The Second Amendment's right to bear arms. D. The 10th Amendment's protection of state sovereignty. Answer A. The 15th Amendment's protection against racial discrimination in voting. Explanation. The 15th Amendment prohibits racial discrimination in voting. Courts analyze voter ID laws under Section 2 of the Voting Rights Act, which bars practices that disproportionately burden minority voters. Shelby County v. Holder 2013. B. Incorrect. The Fourth Amendment protects against searches, but voter ID laws concern for rights, not privacy. C. Incorrect. The Second Amendment applies to gun rights, not election laws. D. Incorrect. The 10th Amendment preserves state powers, but states cannot violate federal constitutional protections. Question 13. In a multi-location scenario where consistency requirements must be met, a city enacts a local ordinance restricting non-citizens from renting homes. Advocacy groups challenge the ordinance. Which constitutional principle is most relevant? A. The Supremacy Clause and federal immigration law preemption. B. The Takings Clause of the Fifth Amendment. C. The Privileges and Immunities Clause. D. The Establishment Clause of the First Amendment. Answer A. The Supremacy Clause and federal immigration law preemption. Explanation. The Supremacy Clause, Oracle Roman se, prevents states and cities from contradicting federal immigration laws. Courts have struck down local restrictions on non-citizen housing, as in Lozano v. City of Hazleton 2013. B. Incorrect. The Takings Clause applies to government seizure of property, not rental restrictions. C. Incorrect. The Privileges Immunities Clause protects state-to-state rights, not immigration status. D. Incorrect. The Establishment Clause applies to religion, not housing laws. Question 14. During a major transformation where existing methods for accommodating disabilities are being reassessed, a government agency adopts new building codes that fail to include ramps for wheelchair access. A disability rights group challenges the decision under which law? A. The Americans with Disabilities Act, ADA. B. The Fourth Amendment's protection against unreasonable searches. C. The Fair Housing Act. D. The First Amendment's right to free expression. Answer A. The Americans with Disabilities Act, ADA. Explanation. The ADA requires reasonable accommodations for individuals with disabilities in public spaces. Failure to provide wheelchair access violates Te Roman 2 oblique services or Title Roman 3 oblique accommodations of the ADA. B. Incorrect. The Fourth Amendment concerns privacy, not disability rights. C. Incorrect. The Fair Housing Act applies to housing discrimination, public spaces. D. Incorrect. The First Amendment protects speech and expression, not disability accommodations. Question 15. In a situation where formal requirements conflict with freedom of speech, a university enacts a policy banning student protests in certain areas. A student group challenges the policy. Under which legal doctrine would courts evaluate this case? A. The Public Forum Doctrine under the First Amendment. B. The Establishment Clause of the First Amendment. C. The Due Process Clause of the 14th Amendment. D. The Takings Clause of the Fifth Amendment. Answer: A. The Public Forum Doctrine under the First Amendment. Explanation: the Public Forum Doctrine governs speech in public spaces. Universities, as government entities, must allow free speech in public areas unless restrictions serve a compelling interest. Tinker v. Des Moines, 1969. B. Incorrect. The Establishment Clause deals with religion, not speech restrictions. C. Incorrect. The Due Process Clause might apply, but the core is speech rights, not procedural fairness. D. Incorrect. The Takings Clause applies to government seizure of property, not speech restrictions. Question 16. When developing a solution that must address opposing needs, a state law mandates drug testing for all welfare recipients. A lawsuit is filed challenging the law. What is the most relevant constitutional argument? A. The Fourth Amendment's protection against unreasonable searches. B. The Commerce Clause's regulation of state policies. C. The Second Amendment's right to bear arms. D. The Contract Clause's protection of private agreements. Answer: A. The Fourth Amendment's protection against unreasonable searches. Explanation: the Fourth Amendment protects individuals from unreasonable searches. Courts have ruled mandatory drug tests without suspicion unconstitutional in some welfare cases. LeBron v. Secretary of Florida, 2014. B. Incorrect. The Commerce Clause applies to interstate business, not welfare policies. C. Incorrect. The Second Amendment concerns gun rights, privacy rights. D. Incorrect. The Contract Clause protects economic agreements, not government-imposed testing. Question 17. While managing a hybrid approach where timing issues affect implementation, a state legislature enacts a law restricting early voting on Sundays. A lawsuit is filed arguing the law disproportionately affects black voters. Which legal principle applies? A. The Voting Rights Act's protection against racial discrimination. B. The 10th Amendment's state sovereignty protections. C. The Fifth Amendment's Due Process Clause. D. The Contract Clause's regulation of state laws. Answer: A. The Voting Rights Act's protection against racial discrimination. Explanation: the Voting Rights Act, VRO of 1965, prohibits voting laws that disproportionately impact racial minorities. Courts examine whether intentional discrimination or disparate impact exists. Brovich v. DNC, 2021. B. Incorrect. The 10th Amendment does not allow states to violate federal voting protections. C. Incorrect. Fifth Amendment applies to federal actions, not state election laws. D. Incorrect. The Contract Clause does not regulate voting rights issues. Question 18. During a major transformation where existing methods of law enforcement are being reassessed, a city implements a policy allowing police to stop and search individuals without probable cause. Which constitutional principle is most relevant in challenging this policy? A. The Fourth Amendment's protection against unreasonable searches and seizures. B. The 10th Amendment's protection of state sovereignty. C. The 8th Amendment's prohibition of cruel and unusual punishment. D. The First Amendment's protection of free speech. Answer: A. The Fourth Amendment's protection against unreasonable searches and seizures. Explanation: the Fourth Amendment requires probable cause or warrant for searches and seizures. The Supreme Court in Terry v. Ohio, 1968, allowed stop and frisk searches with reasonable suspicion, but random, suspicionless searches are unconstitutional. B. Incorrect. The 10th Amendment protects state powers but does not override constitutional rights. Correct. The 8th Amendment deals with punishment, not searches. D. Incorrect. The First Amendment concerns speech, not privacy rights. Question 19. In an environment where different components must interact efficiently, a new federal law requires states to enforce stricter environmental regulations. A state sues, claiming this violates its rights. What constitutional issue is raised? A. The Supremacy Clause's precedence of federal law over state law. B. The Second Amendment's right to bear arms. C. The Establishment Clause's restriction on government-endorsed religion. D. The Fifth Amendment's protection against self-incrimination. Answer A. The supremacy clause is precedence of federal law over state law. Explanation. The supremacy clause, Article Omens Clause 2, establishes that federal laws override conflicting state laws. If the federal government enforces environmental laws, states must comply. Massachusetts v. EPA 2007. B. Incorrect. The Second Amendment is about gun rights, not federal versus state power. C. Incorrect. The Establishment Clause concerns religion, not environmental laws. D. Incorrect. The Fifth Amendment protects individuals, not states. Question 20. When implementing new protocols in a shared environment, a school district requires students to stand during the Pledge of Allegiance. A student refuses and faces disciplinary action. What constitutional principle applies? A. The First Amendment's protection of free speech. B. The 10th Amendment's protection of state powers. C. The 14th Amendment's Equal Protection Clause. D. The Fourth Amendment's protection against unreasonable searches. Answer A. The First Amendment's protection of free speech. Explanation. The First Amendment protects students' rights to free expression, including refusing to salute the flag. West Virginia v. Barnett, 1943. Schools cannot compel political speech. B. Incorrect. The 10th Amendment concerns state power, not individual rights. C. Incorrect. The Equal Protection Clause applies to discrimination, not forced speech. D. Incorrect. The Fourth Amendment deals with searches, not speech. Question 21. While managing a hybrid approach where timing issues affect implementation, a new law requires voter ID at the polls but fails to provide IDs in time for an election. What constitutional issue arises? A. The 14th Amendment's Equal Protection Clause. B. The Second Amendment's right to bear arms. C. The Third Amendment's restriction on quartering soldiers. D. The Sixth Amendment's right to fair trial. Answer A. The 14th Amendment's Equal Protection Clause. Explanation. If law disproportionately affects certain voters, it may violate the Equal Protection Clause. Courts examine if burdens on voting rights are justified. Crawford v. Marion County, 2008. B. Incorrect. The Second Amendment concerns firearms, not elections. C. Incorrect. The Third Amendment relates to housing soldiers, not voting. D. Incorrect. The amendment applies to criminal trials, not elections. Question 22. During an emergency response where multiple areas are impacted, a state orders a mandatory evacuation, but some citizens refuse to leave. What legal authority allows the state to enforce evacuation? A. Police powers under the 10th Amendment. B. The First Amendment's free speech protections. C. The Second Amendment's right to self-defense. D. The Fourth Amendment's protection against searches. Answer A. Police powers under the 10th Amendment. Explanation. States have broad police powers to protect public health and safety. Courts have upheld mandatory evacuations in emergencies. Jacobson v. Massachusetts, 1905. B. Incorrect. The First Amendment does not protect refusing evacuation. C. Incorrect. The Second Amendment does not override emergency orders. D. Incorrect. The Fourth Amendment does not apply evacuation orders. Question 23. In a situation where resource allocation becomes critical, a hospital denies life-saving treatment based on a patient's age. What constitutional principle is relevant? A. The 14th Amendment's Equal Protection Clause. B. The Fifth Amendment's Due Process Clause. C. The Fourth Amendment's Search Protections. D. The Third Amendment's ban on quartering soldiers. Answer A. The 14th Amendment's Equal Protection Clause. Explanation. Age-based denial of treatment may violate equal protection if it is arbitrary. Courts scrutinize discrimination in life or death decisions. Obergefell v. Hodges, 2015. B. Incorrect. The Fifth Amendment applies to federal cases. C. Incorrect. The Fourth Amendment concerns searches, not medical rights. D. Incorrect. The Third Amendment is irrelevant. Question 24. While examining inconsistencies across various units, a state refuses to issue marriage licenses to same-sex couples. What constitutional principle applies? A. The 14th Amendment's Equal Protection Clause. B. The First Amendment's freedom of speech. C. The 10th Amendment states rights. D. The Fifth Amendment's double jeopardy rule. Answer A. The 14th Amendment's Equal Protection Clause. Explanation. The Supreme Court ruled in Obergefell v. Hodges, 2015 that same-sex marriage bans violate equal protection. B. Incorrect. The First Amendment does not apply to marriage laws. C. Incorrect. The 10th Amendment does not allow states to violate rights. D. Incorrect. The Fifth Amendment concerns criminal law. Question 25. When improving a process that shows unexpected results, Congress passes a law increasing background checks for firearm purchases, but some argue it violates their rights. What constitutional issue is raised? A. The Second Amendment's right to bear arms. B. The 10th Amendment's reservation of state powers. C. The Fourth Amendment's protection against searches. D. The First Amendment's freedom of speech. Answer A. The Second Amendment's right to bear arms. Explanation. The Second Amendment guarantees the right to own firearms, but the Supreme Court allows reasonable regulations like background checks. District of Columbia v. Heller, 2008. B. Incorrect. The 10th Amendment concerns state versus federal powers, not gun rights. C. Incorrect. The Fourth Amendment protects privacy from searches, not gun ownership. D. Incorrect. First Amendment concerns speech, not firearm laws. Question 26. While analyzing the root causes of sequential problems in law enforcement, a city requires all officers to wear body cameras, but some officers claim this violates their rights. What constitutional principle is at stake? A. The Fourth Amendment's protection against unreasonable searches. B. The First Amendment's protection of speech. C. The 10th Amendment's state sovereignty. D. The Fifth Amendment's due process rights. Answer A. The Fourth Amendment's protection against unreasonable searches. Explanation. The Fourth Amendment protects individuals from unreasonable searches and courts balance privacy rights versus public safety when considering police body cameras. If officers are recorded constantly, it may be seen as invasive. Riley v. California, 2014. B. Incorrect. The First Amendment concerns speech, not surveillance. C. Incorrect. The amendment concerns state versus federal powers, not privacy. D. Incorrect. The Fifth Amendment deals with legal proceedings, not searches. Question 27. During the introduction of new methods where coordination is essential, a state passes a law banning protests near government buildings. What constitutional issue is raised? A. The First Amendment's protection of free speech and assembly. B. The Fourth Amendment's protection against searches. C. The Second Amendment's right to bear arms. D. The Eighth Amendment's prohibition of cruel punishment. Answer A. The First Amendment's protection of free speech and assembly. Explanation. The First Amendment guarantees freedom of speech and peaceful assembly, including protests. Governments can regulate the time, place, and manner of protests, but blanket bans near government buildings are often unconstitutional. McCullen v. Coakley, 2014. B. Incorrect. The Fourth Amendment deals with privacy and searches, not protests. C. Incorrect. Second Amendment concerns firearms, not speech. D. Incorrect. The Eighth Amendment applies to punishment, not speech restrictions. Question 20. When developing a solution that must address opposing needs, Congress passes a law that requires companies to provide paid family leave, but some businesses argue that it violates their rights. What constitutional principle is relevant? A. The Commerce Clause's regulation of interstate business. B. The First Amendment's protection of speech. C. The Second Amendment's right to bear arms. D. The Fourth Amendment's protection against unreasonable searches. Answer A. The Commerce Clause's regulation of interstate business. Explanation. The Commerce Clause, Article I, Section 8, allows Congress to regulate business activities that affect interstate commerce. If paid family leave impacts businesses operating across state lines, Congress can justify the law under this power. Wicker v. Filburn, 1942. B. Incorrect. The First Amendment is about speech, not business regulation. C. The Second Amendment concerns gun rights, not employment laws. D. Incorrect. The Fourth Amendment covers searches and seizures, not labor laws. Question 29. While investigating a complicated issue between different jurisdictions, a state enacts a law that restricts out-of-state businesses from selling products within its borders. Which constitutional principle applies? A. The Dormant Commerce Clause's restriction on state interference with interstate commerce. B. The Fifth Amendment's protection against self-incrimination. C. The Seventh Amendment's right to jury trial in civil cases. D. The Eighth Amendment's prohibition of excessive fines. Answer A. The Dormant Commerce Clause's restriction on state interference with interstate commerce. Explanation. The Dormant Commerce Clause prevents states from enacting laws that burden interstate trade. State law favoring local businesses over out-of-state companies is unconstitutional. Granholm v. Heald, 2005. B. Incorrect. The Fifth Amendment protects individuals, not businesses. C. Incorrect. The Seventh Amendment applies jury trials, not commerce. D. Incorrect. The Eighth Amendment concerns punishments, not trade laws. Question 30. During an emergency response where multiple areas are impacted, the state imposes a curfew to prevent looting, but citizens argue it infringes on their rights. What constitutional issue is at stake? A. The First Amendment's protection of peaceful assembly. B. The Third Amendment's restriction on quartering soldiers. C. The Sixth Amendment's right to legal counsel. D. The Second Amendment's right to bear arms. Answer A. The First Amendment's protection of peaceful assembly. Explanation. The First Amendment protects the right to peacefully assemble, but courts allow temporary curfews during emergencies if they serve compelling interest. Komatsu v. United States, 1944. B. Incorrect. The Third Amendment is about housing soldiers, not curfews. C. Incorrect. The Sixth Amendment applies to criminal trials, not public restrictions. Incorrect. The Second Amendment protects gun ownership, not public gatherings.